Okay, who says B, ESPO? ESPO is it's the International Agreement for Environmental Assessment in Transboundary Actions. Is anybody raise their hand for ESPO? The World Heritage Convention. No?
Unless you just count observers.
Well, there is a little star at the top of the asterisk, in some form.
Okay.
Okay, all of the above? Does anybody guess for all of the above? Anybody say none of the above?
I'm opting for that one.
Yeah? Okay, just very briefly, like I said, I had a big long spiel on Aarhus. I'm not going to go into it too much. I think it is pretty much the, hopefully it's not the high watermark, but it's sort of the standard that's been set today. And it specifically gives individuals and NGOs standing. Now it's actually, there's two pieces to Aarhus. Aarhus requires that the signatory countries sign into the local legislation the three pillars of Rio: participation, information, and then access to justice. But what it also does, which is unique, is it gives it established what's called the Compliance Committee. And under the Compliance Committee, you can actually, as an NGO or an individual, go to the Compliance Committee, file what's called a communication, and claim to this Compliance Committee that your state or the nearby state or a state has not complied with the first tier. And if they haven't done that, then the Compliance Committee can actually issue a report saying that they find that the state is not in compliance, and this is where it falls down. There's a recommendation that has to be adopted by the members of the party, which basically says, yes, the state hasn't done what they're supposed to do, and we recommend that you change it. We'll help you change it. We'll do this and we'll do that. This does work. I've seen it in action. Most of you know the late Svetlana Kravchenko. She was a big fan of this. She was one that actually was in the negotiating committee to begin with. I studied under her, and so I got to do some work with her on Aarhus, and it does work. It's not perfect. It's very difficult. You cannot award. You cannot stop a project. You cannot award damages. You can't do anything, but you can get countries to implement the provisions of the convention. The other problem with Aarhus is it's very limited. It was set up after the fall of the Berlin Wall, and it's pretty much limited to European countries. Western Europe was trying to get Eastern Europe up to speed on their environmental legislation, and so it was an attempt to bring them up to speed quite a bit. This is used quite often, by the way, for some of the Western countries as well. Austria, for instance, seems to be a common sort of recipient of these kind of complaints. Yes?
Actually, I was trying to draw this code.
Aarhus is trying, and they're trying to, we talked about that a little bit yesterday in our smaller session, and it's been pretty much, I think, rejected in Asia. I think Africa is not too happy about it, but that was the grand goal, was to try to get the world to sign up to it, which would be spectacular. But once again, we don't have any of this, global perfect answers. ESPO, it is, this is a bit of a trick question, so apologies to those who didn't think this applies, but there was a recent decision that at least the Secretariat can consider communications or complaints from the public, and so it leaves it up to the Secretariat. And I think that's, an area we need to explore, because I think under most of these conventions, secretariats have the ability to raise something to the member of the parties or to whatever mechanism may be in there. So I think it's, an opportunity to ask questions of secretariats in the case of violations of the treaty. Can't guarantee anything's going to happen. It's going to depend upon a lot of things, politics, the view of the secretariat and all kinds of things. But they do have the power normally to take complaints up to the treaty, to the members of the party, the members of the treaty. The World Heritage Convention, you can actually, once again, it's through the Secretariat in the first, in all instances, but in the initial application for listing, you can actually file a notice with the Secretariat either in support or not in support of it, of the application. And then certainly once it's on the list, if you feel that it's endangered for whatever activities, you are free to go to the committee and raise the issue with them that this particular World Heritage site is now under threat. And you try to get it listed. So next. So the answer is all of the above if you take the asterisk into consideration. Yes.
I think regarding World Heritage, what needs to be added, of course, from the ISM perspective, and also the role of IUCN itself as an advisor. So since you put individuals and NGOs there, I mean, this is quite an interesting participation also from.
So somebody came to the IUCN and said that we think that this particular, if we think that all marine World Heritage sites and all mountain sites that are going to lose their reefs because of ocean acidification and snow top and then the melting of the snowpacks. When we came to IUCN, would you entertain that suggestion?
No. I mean, what I'm referring to is that IUCN plays an advisory role also in the evaluation of the sites.
Yeah.
You
you do all the natural sites, I think. Is that right?
Yeah.
So whenever there's a submission.
And then you have eco
Yeah, they do the cultural sites.
Yeah. So that's the.
But could you take? I guess you could take a complaint to the. You may not want to, but I mean, I guess conceivably you could take. You know, if you felt one of the sites that you had signed off on was under threat.
I mean, of course, the advice that these NGOs or IGOs, of course, IUCN is something in between. The advice that they are giving, you know, can be positive or negative also.
Yeah.
To list or not to list, or that it's threatened and needs to be removed from the list or whatever. I mean, that I don't know.
Yeah, and I think that's something that hasn't been, well, maybe it has been explored enough, but at least not that I'm aware of. Okay, regional human rights conventions. I don't think I have a question on this one. Next slide, please. Oh, I do. Okay, which of the following human rights conventions have specific environmental language? Now, keep in mind that, oops, hold on a second. Keep in mind that sometimes human rights conventions are very, very powerful sort of things if you can get into court. There's some disadvantages to them, one of which is you normally have to exhaust all the remedies back in your home country, which is a big hurdle. There is an exception if you don't have an adequate remedy back in the home country, so you can argue that as well, but it's very difficult to get in here. Once you get into them, however, they can be quite powerful in some instances. The European Human Court, European Court of Human Rights is quite powerful, as a matter of fact. But, okay, so let's go down the quiz here. Okay, so which of the following, now this is a true or false question. Does the European Convention on Human Rights, is there a specific environmental language included in it? How many people say yes? Raise your hand. Yes. I thought the answer was no, but
I'm up in this stage.
yeah, okay. So
It's more recent. No, it's more recent language.
what I think you're probably referring to is there's derivative rights that come out of it. So they're embedded in the right to life, the right to family, those kind of things.
Yeah.
So. And that's another hurdle for a lot of these human rights conventions to get there, is that you've got to actually be able to say that the environmental damage that's been done rises to the level of a human rights violation under the right to life, right to family, whatever it may be. So it is there. In fact, there's been quite a couple jurisprudence that's been very, very, very valuable for the plaintiffs, because they've actually been awarded damages. Damages. Okay, how about the next one? African Charter on Human and People's Rights. Is there a specific environmental language in that? Okay, raise your hand if you think yes. Okay, the answer is yes. Okay. Next one, Asian Human Rights Charter. Raise your hand if you think the answer is yes. Not that I could find. Okay, next one. Arab Charter on Human Rights.
It's more recent, so there's more hope.
More recent, more hope. Okay. Yeah, no, not that I can find either. Okay, next one. UN Convention on the Rights of the Child. There's an asterisk. No, how many people say no? Okay, the answer is, the asterisk appears, if it's limited to food and clean water, yes, but there is something in there. Okay, and then the sixth and final one. American Convention on Human Rights. Is there specific environmental language in there? How many people think in the American Convention on Human Rights? Okay. The asterisk, yes, but it's only in the recent protocol, which I don't think has been signed by a whole lot of countries yet, but it's in there. Yes.
Is there anything on food and clean water in the European Convention?
I don't think so. It's a right to family and a right to life.
Oh, clean water.
Okay, next slide, please. Okay, so that was it for the regional human rights conventions. I'm not going to talk about that anymore unless anybody has any additional questions. Okay, so let's move into multinational development banks. Okay, so quick through these. Okay, so the World Bank obviously is the one that springs to mind. There's actually two elements to the World Bank, one of which is the public financing, the second is the private financing. And then next look, the North American Development Bank, the Inter-American Development Bank, there's the European Bank for Reconstruction and Development. That is the Asian Development Bank and the African Development Bank, and I think there's one more. Yep, there's the Arab Development Bank. So there's quite a few development banks out there. All of them, as far as I know, except for maybe the Arab Bank, have some sort of mechanism. So if your project in your home country is being financed in any way by any of these development banks, most of them have a grievance mechanism by which you can bring a complaint. Now, these are kind of unusual, and I know the World Bank Inspection Panel, maybe Owen would want to say something about the European Bank for Reconstruction and Development for a second. But under the inspection panel within the World Bank, there is a very, very specific process. There is a body that reviews the requests called the inspection panel. And just a couple points about that, and it's probably the same way with the European one as well. But who can bring a complaint? It's actually pretty broad. Anybody can bring a complaint, just about. Any locally affected people or NGOs that are representing those people. It can be done in a confidential manner. So from that perspective, it's a great mechanism. The downside, really, to these things, there's a couple. One is that the defendant, if you will, they're not called defendants, but the defendant is the World Bank or the Multinational Development Bank, NDB itself. And it's the bank's management who approved the project. They're the ones. It's not the actors. It's not even the foreign government where the project is located. It's the development bank itself. And the cause of action, if you will, that you have against it is that the World Bank failed to use follow its own policies in granting the loan. So if there's an environmental project, a project that's impacting the environment, just because you get a bad environmental impact doesn't mean that you have the cause of action. What you have to show is that the World Bank didn't follow its own policies in considering those policies. Same with human rights. There's some displacement policies on there. There's some rights of indigenous people policies in there. And just because they're displaced, or just because their rights have been violated, if you will, it doesn't give you a cause of action. You have to show that the World Bank didn't appropriately consider that. Owen, did you want to say anything about the...
If you've got a minute, or I can do it at the end, just
Sure,
to talk
go
about.
ahead.
I just wanted to set out the EBRD. I should say an important one that you've omitted is the EIB, the European Investment Bank, as well, which is a global player, if you like, on behalf of the European institutions. I sit on the project complaint mechanism of the EBRD, which is one of a number of, as you pointed out, one of a number of these mechanisms. And I mean, although each of these mechanisms are different because they're structured slightly differently, and they also, each of them apply that particular institution's safeguard policies, social and environmental safeguard policies. So of course, each applies slightly different rules. And that can create some quite bizarre situations where, and has done, where many projects now are co-financed. And so you may have complaints taken to two mechanisms simultaneously. And each institution has to review the compliance of, or each mechanism has to review the compliance of each institution against slightly different rules on the same set of facts and everything else. So it can get quite complex. However, the mechanisms are coming closer and closer together, and there is more active coordination. And each of their operational policies, the bank's safeguard policies, have been readdressed in recent years so that they can coordinate, they can work out what requirements are needed to satisfy and coordinate what's needed to satisfy the requirements of 2 or more institutions. So it cuts down on confusion. And there is now a process, a sort of a standard process for the sharing of information between the institutions, an annual meeting of what's called the International Accountability Mechanisms, or IAMs, and it's in 2 weeks' time in Luxembourg this year, and that's actually a very useful meeting of about 3 days of the banks. And for the last 2 years, it has also been followed then with a day-long conference, which is open to the public and where these institutions, have an opportunity to explain what they do, recent cases, recent decisions, why things work the way they did. So there is a community of practice developing with these institutions where they're sharing their learning, what they're doing, how they're interpreting their own safeguards, where there are gaps and problems, and that's a very, very interesting process. I find it interesting from the perspective of a global administrative law analysis of, a gathering set of administrative practices. But just for one more minute to explain how the EBRD's project complaint mechanism works. The EBRD lends to private sector clients, but those clients are very often state-owned or controlled companies. So, though you're not lending to the state as an entity, you are very often lending to an entity that the state directly controls and will be heavily involved with. Our complaints in recent years have been thermal power stations, hydro. We've had a rash of hydro recently. It was an issue that came up in a previous workshop that the age of large hydro was by no means dead. Oil and gas pipelines, railway projects, motorway projects, and port facilities. There are 2 functions, 2 kind of jurisdictions, if you like. One is compliance review, to check that the institution, management of the bank, met all of the social and environmental safeguard policies. And the second is where there isn't an allegation of non-compliance, but where stakeholders feel that they've been badly affected by a project, though it may have complied. There's a problem-solving function, a problem-solving initiative function, where you try and restart dialogue, if you like, between the client and the affected individuals. What is interesting about the EBRD is that it has a range of rules that it applies, a range of sources. Of course, it's its environmental and social policy. Currently, it's environmental and social policy 2008. But that policy, which contains a range of performance standards, 10 performance standards, which cover things like indigenous people, resettlement, public consultation and disclosure, biodiversity, pollution control, environmental and social impact assessment, disclosure, etc., etc. But though the policy itself also requires compliance with local law, and also requires compliance with EU environmental rules and standards where applicable. So the Habitats Directive is central, the EIA Directive is central, the Directive for Freedom of Access to Environmental Information is central. So these are absolutely key, and they inform everything that it does. So it's a mechanism for applying the standards of European Union law, in fact, even outside of the borders of the European Union. The safeguard policy is also worded to allow for the application or for the use of applicable international law, and elsewhere refers to general and customary international law, and even more broadly again to international best practice. And this gives tremendous scope to the panel to drag in whatever it thinks or whatever it can stand over as being the best acceptable practice at this time. If the bank has not met what it considers to be the best acceptable practice, again, I would argue an example of a sort of global administrative law type creature. In terms of standing or access, individuals affected and NGOs. And the NGOs, that was a recent change to the mechanism was originally conceived as the independent recourse mechanism, was reviewed and then reinvented as the project complaint mechanism. And one of the changes was to allow NGOs, because the original one was too conservative by keeping NGOs out. Of course, NGOs were effectively in, because NGOs were supporting individual complainants. Bankwatch, for example, were very, very, very active. We always understood that the people involved in the mechanism were never happy with the idea of NGOs being excluded, but now of course this was drafted by the bank's Office of the General Counsel, who were more conservative, but they eventually relented on the new draft and allow NGOs to be actively involved. There are all sorts of arrangements to protect complainants, confidentiality where they request it. In some jurisdictions you might not want the authorities to know that you're making a complaint when the authorities, the state may be very heavily involved in the project. various types of technical or other resource assistance can be given to complainants to assist them in improving their complaint or providing information that's required. The PCM experts themselves, usually it's a two-stage process. There's an eligibility assessment, and then there will be a go to compliance review and or problem-solving initiative. And quite importantly, the PCM experts, who are independent of the bank, they draft the terms of reference for example, compliance review. So really and honestly, that can be as broad, as wide-ranging, involving as many resources as the PCM experts consider necessary. And so usually our standard way of drafting them is to give the expert who's looking at who's doing a compliance review, for example, a free hand in terms of contracting additional expertise, technical or otherwise. Often, for example, local legal expertise if you want to know about compliance with local laws, etc., etc. So basically it becomes an informal enforcement mechanism for a series of bodies of environmental and social protection rules.
Okay, thank you. Does anybody have any questions from Rosa? No, I just to pick up on one or 2 points. The first point is that all these mechanisms, well, not the courts that I talked about, but certainly the Auditors and Compliance Committee and the inspection panel at the World Bank and most of these are supposed to be sort of non-confrontational